Hello, I'm Catherine Gannon, founder and managing partner of Gannons, a boutique commercial law firm focused on private companies. We service all of your everyday needs, from buying companies, selling companies, attracting investment, attracting employees, putting in place employee incentives. Everything that you're going to need in daily business we cover and specialise in. Due diligence, you've got to look at what are you buying, you've got to look at your resources, but most importantly, you need to look at your risk. In the company you're buying, where are the risk factors? So for example, if you're buying an IP company, so a company that's developed some bit of kit, you need to be making sure that they own it. They haven't stolen it from someone else. They've registered all the rights. That's the sort of due diligence you need to do. So the amount of due diligence very much depends on the size of the business and its business lines. Many people do their own basic due diligence before they come to lawyers, and that's great because it can be very time consuming. Other people leave the whole job to the lawyers. It all depends on budgets, time constraints and appetite to get stuck into nitty gritty. In addition to the legal due diligence, the contracts, what do they say, what do they mean? There's also financial due diligence. Depends on your negotiation power. Obviously, if you're a buyer, you want to be deferring. If you're a seller, you want all the cash on the table. I think most sellers realise they're not going to get the cash on the table. In terms of deferred payments, earn-outs is what they're known as, and they're very common. Most of our deals will have an earn-out, and it can range between 2 and 3 years typically, based on future performance. So it's very common, and also it's quite common to lock in the key players because you need them to earn the earn-out. Another try-on from buyers will be to try and pay in cash and shares. That used to be popular, but since the dot-com bust 20 odd years ago, there's not so many cash and share deals around. With bricks and mortar, you don't tend to see earn-outs because you know what you're buying and you've got it. With high-tech businesses, the ones we act for in and around the southeast, which normally involve IP, yes, an earn-out is very common for 2 to 3 years because you've got to see how that IP performs. You've got to see, do the staff stay? It depends to a degree as well. What is the buyer actually buying? Sometimes he's buying the team because it's so hard to find good people in London, especially in London. So if you're the seller, you want to make sure you've got a good team in place and you've secured their interest via various forms of share incentives. Warranties are Rottweilers, and also they do have meaning. They all tie in with something called the disclosure letter. What the seller has to do is disclose all the problems, because if they've been disclosed, it's buyer beware. The buyer then can't claim on the warranty. So what you do is you have general warranties, and then they're eaten away by what's been said in the disclosure letter. And that, of course, then goes back to the price. So they're very common. There's lots of negotiation. Sellers will resist. They don't want to have a warranty worth more than the total consideration they're getting. A warranty worth half of the consideration they're getting is steep. But again, you've got to look at the particular circumstances and weigh up the risks. It's tax treatment, it's how it's dealt with on the balance sheet. That's one of the big differences. And then the practical difference is, with a company, you buy warts and all. You buy all liabilities as well as the assets. With an asset purchase, you can carve out and only buy the elements of a business you quite fancy. And sellers will be resisting asset sales because the seller will often end up paying more tax. Because with an asset sale, the money comes into the company, and then the company has to pay corporation tax, and then it's only what's left after the corporation tax is paid that then has to be dividended out to the shareholders. Whereas with a share acquisition, the money goes straight to the shareholders because they're selling their shares. So usually sellers want a share sale, not an asset purchase. If you're buying a business, a share sale, you buy everything, including any claims there may be lurking, all the contractual rights, you're buying everything, all the disputes, grievances, risks of litigation, continuity of employment, you're buying the works. Whereas with an asset transfer, you have, the employees have something called Cheapie Protection, and they transfer across. And again, the effect of Cheapie is to really put these employees in the same position they would have been in if there was a share purchase, i.e. all of their contractual provisions are preserved. And there's quite strict rules attaching to Cheapie relating to how long you have to wait before you can then change the terms and conditions, because often a buyer will want to harmonise the terms and conditions with those of their existing workers. But that is not as straightforward as one would hope. There is a waiting game and a process you have to go through to avoid falling foul of Cheapie.